So you have a quorum. A vote of the 2 of the 3 will be a valid action of the board of directors. So even though only 2 of the 5 voted for something, because you validly called the meeting, and because the quorum showed up, the vote of the 2 is binding on the entire board of directors. You also hear the term proxy. Proxy is the authorization given by a shareholder to have somebody act in their place. So by giving a proxy to someone, the shareholder cannot attend the meeting and have somebody else vote in their place. And that can either be another shareholder, one of the officers or directors, or just a completely different third party. You should also be aware of something called securities regulations. Securities are when somebody invests something of value in something else and is relying upon a third party to make money for them. So, for example, in a corporation, somebody buys a share of stock and they don't intend to run it. And it's because Valerie told them that if you put money in this company, I will run it for you and I will make you money. That's a security. And whenever you have a situation like that, whether it's in a corporation, a partnership, when somebody says, put your money in here and I will make money for you, that's a security, and it's heavily regulated by the federal and state governments. That's because in the past there was a lot of wrongdoing and people invested a lot of money and lost it. So whenever you have a corporation, anytime you have a situation, but there's oftentimes in a corporation where somebody is putting in money, they're not going to run it, they're not close to it, but they're relying upon someone else to make money, then you should know that there's another layer of regulation called securities regulation. If the people that put the money in are actually going to run it, that's not really a security. If the people that put the money in are all closely related, it is a security, but there is an exemption under the laws for having to fall within the heavy regulation. So for example, in my firm, if you get a situation where you're getting a bunch of strangers putting in money, giving it to someone else to make money for them, we will say we don't handle that type of corporate formation or business formation, because there's a heavy amount of regulation and there's a heavy amount of liability for the attorneys and accountants that get involved in having other people give money to one person to make money for them. But if people come in and say, well, we 2 people are forming a business, we're going to run it, then we'll help them to form that kind of a business, because although there may be securities aspects to them, it's usually not a problem. So we know that you file articles of incorporation to form the corporation. Bylaws are a more detailed set of rules to run the corporation, such as how to hold meetings, how to give notice of meetings, who are the officers and what are the duties of the officers, who can sign checks if there's no corporate resolution. All of those types of rules are often contained in the bylaws. And you would help an attorney draft the articles, draft the bylaws, do the initial meeting of the stockholders, the initial meeting of the directors, where they would elect the board of directors elects the officers, you would pass the bylaws, you would authorize the filing of the appropriate types of applications that we talked about to get federal ID and state ID numbers. All of these would go into a corporate record book, which would contain the minutes, the articles, and the bylaws. Sometimes corporations have corporate seals. I haven't gotten a corporate seal in ages, but I remember when I first started practicing law back in the 70s and 80s, it was very common for corporations to have corporate seals, but I haven't ordered one in ages. And finally, you would issue stock certificates to the stockholders for their stock. Something else that you may file is an application for a trade name. That is, sometimes you'll have a corporation and the corporate name will be ABC Inc., but you've decided that you're going to do business under Best Donuts, Best Hawaiian Donuts. And so you want to register this trade name or even a trademark with the state of Hawaii so that everybody knows that Best Hawaiian Donuts is ABC Inc. And so you may file for a trade name or a trademark for the corporation. And all of that is still done under the DCCA or the Business Registration Division. And if you go to the forms, you'd find the forms for that. Now, if you recall, we mentioned that with a general partnership, you don't have to file anything with any governmental agency to actually have one and start one. Two people can just shake hands and say, let's do this, we're going to do it for money, you've got a general partnership. What the state does do, though, is say that if you do that, you should notify us, and you file a partnership registration statement. So that's filed with the state of Hawaii. So even if you don't file a partnership registration statement, you still have a general partnership, and all the partners are vicariously liable for the liabilities of the general partnership. But you're supposed to file a partnership registration statement. You'd also go ahead and file the same thing, the BB1, the SS4, all of that. What else do general partnerships often need? Yes, a partnership agreement. Can anybody tell me why a partnership agreement is important?
In case the partnership dissolves.
That's good, right. In case the partnership dissolves. Because if the partnership dissolves, wouldn't you like to know in the very beginning what the deal was? What do you think the result would be if Ashley and Brandis formed a partnership, and Ashley put up 90% of the money and did 90% of the work, and Brandis put up 10% of the money and did 10% of the work, but the partnership was fantastic and they made $1 million? How do you think, when they dissolved the corporation, when they dissolved the partnership or terminated the partnership, how do you think that $1 million would be divided? I'm sorry? 50-50, that's right. Because unless you have a partnership agreement that states otherwise, it's 50-50. So that's why you want to have a partnership agreement to say, if this happens, what is the result? Now, if 50-50 was a deal, not too bad. In addition to that, let's say that TJ and Evan formed a partnership, and and let's say TJ put up $40,000, Evan put up $60,000, and TJ wanted to use $100,000 to buy something, and he by himself went to someone without saying anything to Evan, said, hey, we're going to buy this, here's $100,000. Do you think that that would be binding on the partnership and Evan? Yes, it would. Even though he's only one of the two, and even though he put up less than half of the money, every general partner has an equal right to run the business of the general partnership. Unless you put it in the partnership agreement. And there's also a way of letting the world know whether or not partners have certain types of authority. So that if you put it in the partnership agreement, then that in order to spend more than $75,000, that you have to get the agreement of both partners. If TJ went and did that, then TJ just bought that and he has to reimburse Evan because he never got the right authority to spend the $75,000. So there's a whole list of things that would go into the partnership agreement, including how things are divided, how things are run, what type of authority. Very important that they have a partnership agreement. Now, if you recall, we said that you had to file something with the state of Hawaii to have a limited liability partnership. A limited liability partnership is just a general partnership that has filed something with the state of Hawaii that says we are now a limited liability partnership. So everything is the same for limited liability partnership as for general partnership, except that you filed something with the state of Hawaii saying we're a limited liability partnership and therefore no partner has vicarious liability for the liabilities of the entity. So in a general partnership, if the general partnership has a liability for $10,000, each of the general partners must make sure that $10,000 is paid because they're liable. In a limited liability partnership, none of the partners has to make sure that it's paid unless they did something where they would be personally liable, such as they signed the guarantee, or they were the ones that actually left that hole in the floor. Unfortunately, when you have tort liability, which is you should have done something, in a limited liability partnership, you can always say that since, as to the world, both partners have the equal right to run the partnership, each of the partners should have done something. That even if it was Joyce that said leave the hole in the floor, Elizabeth as the other general partner should have known what was going on and she should have made sure that things were done right. So in a limited liability partnership, there is no automatic liability, but you all work for lawyers, not all of you, but many of you work for lawyers, and so they can be very creative about trying to come up with reasons why somebody should be responsible for something. And so there's always in a limited liability partnership an argument that each of the partners, because in a general partnership each partner can run the business, that they all should somehow be liable for things like tort liability. They should have known or should do something. I'll save some paper here. Limited partnership. Now in this case, to have a limited partnership, you must file something with the state of Hawaii. And you have general partners and limited partners. So general partners have the right to run the business, and they are vicariously liable for the liabilities of the business, and limited partners are not. All the other things still apply, that you should have a partnership agreement. You still need to file for the SS4 and the state BB1. All of the other things apply. That's the only difference. And also with respect to general partners, since they're vicariously liable, that they will have unlimited liability for all the liabilities of the limited partnership. Limited liability, limited partnership. That is a limited partnership in which no partner has vicarious liability. So once again, the general partner might be liable for actual liability, but no vicarious liability. One of the things to note in a limited partnership, and it's true for any entity, the limited partner doesn't have vicarious liability. They don't have any right to run the business. But if they actually get in there and they start running the business, if a stockholder says, I'm going to appoint somebody else as president even though I'm the majority stockholder, but I'm going to get in there and tell everybody what to do, you can still have actual